For the focus today, we're going to be talking about drag shows, but specifically the legality of drag shows on a college campus. Now, this year, the Texas A&M University system banned drag shows across all of its campuses, but the decision has been met with some opposition. Back in March, a federal judge ruled that the Draggyland performance on the flagship campus here at College Station could continue, and now a Fifth Circuit Court of Appeals has halted the same ban on the West Texas A&M University campus. The court said that a ban on a drag show on a college campus could be a violation of First Amendment rights. The ban is halted as a lawsuit filed by a group to allow the show to continue plays out in a lower court. So here to talk about all of this and the ongoing case is Jeremy Rosenthal. He is a legal expert joining us out of the McKinney area. Jeremy, thank you for joining us. We do appreciate it. I want to first ask, are you surprised by the 2-1 ruling that came from the Fifth U.S. Circuit Court of Appeals in this?
No, I'm not surprised. And I was somewhat surprised that it didn't get initially blocked at the district court level in North Texas. For the West Texas A&M ban. First Amendment is a very, very hard hurdle to get around for public colleges and universities. The test that's typically applied is called strict scrutiny, which is the highest level of scrutiny that we give for constitutional related issues. And it's very, very hard for the government to survive these types of things. So I did think at some point this would be blocked.
Let me ask you this, and I would love for you to explain to our viewers why, because some of them have said, well, you know what, Texas A&M didn't want it, the Board of Regents didn't want the drag shows to happen on campus. They shouldn't be forced to do this if the Board of Regents didn't really want a drag show on campus. So why should they not be allowed to do that?
We start with this, that Texas A&M is a public university. It's functionally the government. The Constitution applies to government, and you have facilities at both campuses that have public forums. And when you're the public and when you're the government, once you turn on that faucet, once you turn that spigot on, you can't decide what speech you like, what speech or expression that you don't like. And we analyze these things through the lens of is it expressive speech? Is it political speech? Is it something that we ought to be able to talk about on the town square? And when in West Texas A&M and in the instance of Draggyland, the problem is that both of the facilities that hosted these things host congressional debates, host church type events, and each have hosted in the past drag shows as well without incident. So it's very hard to come halfway through and say, well, no, we don't like this. I think one of the things in the West Texas A&M lawsuit that was really very persuasive for the Fifth Court of Appeals in New Orleans was the fact that it was for a nonprofit, that the stated intention behind the drag show was to raise money for LGBTQ suicide awareness and suicide hotlines. Very hard to argue that is not First Amendment activity.
Yeah, the president of West Texas A&M University campus had originally said he had opposed it because he felt that it was demeaning to women and that he equated it to being in blackface. But the court there saying that no, this was a performance that was specific to raise money for a certain cause. I'm curious, how far do you think this goes? I know the lawsuit's still ongoing, but do you see this going even further in the judicial system?
That will be up for the Texas A&M system to decide. The Fifth Court of Appeals in New Orleans is about the most conservative federal district court in the country. The U.S. Supreme Court has a 6-3 split with conservatives. When you are in these types of positions, if you are somebody who is of the mindset that you want to see drag shows be eliminated or limited on college campuses, you have to ask yourself, do we want to push this all the way to the U.S. Supreme Court and then get a bad ruling? Because if you do that, then you've just made your legal position really worse than it was before. So I don't know, once the most conservative district has already ruled against you, I don't know that you necessarily want to push it. That's a question for the A&M system to decide here.
All right, big headlines coming out of the Texas A&M University system. Jeremy Rosenthal helping to bring some context to it. Jeremy, always good to talk to you, sir. We do appreciate your expertise and guidance on that. One other note, the A&M Board of Regents is meeting later this week. They are slated to talk about this during executive session.